There is a relatively new law in Florida, it passed back in 2023, that changed the negligence laws here in Florida with regard to car crash cases. Number one, we used to have a 4-year statute of limitations on these cases. Now it's only 2 years. So if you're in a crash, you have 2 years to bring a case, or the statute of limitations has run and you've lost that right. It used to be where if you were 60% at fault for the case and the other person was 40%, you could get 40% of the value of your injuries. So for instance, if you went to trial and the jury determined that you were 60% at fault, but they also determined that the value of your injuries is $100,000, what you'd end up getting is the $40,000 for the 40% of fault on the other driver. That is the old way. The new way, the new law, if you are more than 50% at fault, then you get nothing. So if you're 51% at fault, you get zero. And so the way that's affected cases is now when it's a tough 50-50 case that walks into our door and asks us to represent them, we have to be more careful about taking that case because number one, those are hard cases. Number two, if the client loses and we had to file a lawsuit, the defense could come after the client for their attorney's fees and costs. And so we never want to put a client in a bad spot on a tough case like that. In the past, we'd feel confident going to court and taking that there because we know some fault's going to be put on the other driver. But now it's a high stakes game of chicken because if the client's found 51% or more at fault, they get zero. And then they could leave the table owing money. And that's the last thing any attorney would want to have happen to their client. It's impacted the number of cases that we would sign up. It's impacted the cases that we take, and it's impacted how we present cases in trial. That's the way the new law has affected the negligence law here in Florida.